Welcome to Winning Isn't Easy. I'm Nancy Cavey. I'm a national ERISA and individual disability attorney. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say it, so I said it. Nothing, however, will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Life insurance claims are a whole other ballpark in the disability claims world. And today I'm going to walk you through some of these claim stories and discuss how it might be relevant to you. The topics are going to include, can you sue a fiduciary who fails to properly enroll your spouse in an ERISA life plan? In other words, it's not going to be you, by the way, it'll be your estate. Number two, is speeding a crime that can result in a life insurance claim being denied? And three, can a life insurance company deny payment of benefits based on alleged contaminated blood alcohol testing? This is really exciting stuff. I find it fascinating. But we're going to take a break before we get started and dive in.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Can your estate sue a fiduciary who's failed to properly enroll your spouse in an ERISA life insurance plan when you pass away and the carrier denies the claim? Well, unfortunately, many human resource staff doesn't properly help their employees enroll in life insurance plans. That can be disastrous. If an employee passes away and the beneficiary claims life insurance benefits, one of the most common defenses that a life insurance carrier is going to raise is, hey, your loved one wasn't properly enrolled in this ERISA life insurance plan, so we're sorry that they've passed, but we're not going to pay any benefits. That's the first line of defense. It's called, there is no coverage. Now, what is going to happen is the life insurance company is going to open up a claims file, and they're going to get material from the employer, from the employee benefit department, and they're going to be looking for what the plan enrollment process was and whether or not the plan enrollment process was followed. Now, that is exactly what happened in the case of Gimino versus NCHMD. Gimino's spouse, Dr. Palaga, was a physician who worked at NCHMD. The human resources staff at NCHMD helped Dr. Palaga enroll for life insurance benefits, and he named his spouse as the primary beneficiary. He accepted life insurance benefits in the amount of $150,000, which is paid for by his employer. He also elected to pay for a $350,000 supplemental life insurance policy, but he was required under the terms of the plan to submit evidence of insurability. Guess what? The human resource staff didn't provide him with the form, and they never told him that it was necessary to complete the form. And as a result, he never completed or submitted the form. But his employer deducted premiums for the supplemental coverage from his paycheck for 3 years, and they repeatedly told him that he had coverage. When Dr. Palaga died and his spouse submitted a claim for the life insurance proceeds, the life insurance company said, too bad, so sad. We'll certainly pay the underlying base benefits, but we're not paying the supplemental benefits because the evidence of insurability form was never submitted. Of course, this case ends up in federal court in the 11th Circuit, where there was a question as to what type of claim, if any, the spouse had under ERISA law. Now, ERISA is a federal statute, and it governs employee benefit plans and policies such as life insurance. So the spouse sued CHMD and NCHMD Healthcare for the benefits under ERISA Section 502A1B. The claim was dismissed on the basis that they didn't have any obligation under the plan to pay supplemental benefits. So what happened was the lawsuit was amended to assert a claim for what's called equitable relief under 502A3. Now, the spouse alleged that both CHMD and NCHMD were fiduciaries, and under the fiduciary obligation, they had, in good faith, an obligation to explain to the doctor the enrollment process, make sure that the forms were submitted, completed and submitted. And so ultimately, the court has to decide whether or not the complaint can be amended based on this particular motion. And the district court says, look, we're not going to allow you to amend this lawsuit on the basis that you are seeking monetary relief, because that's not equitable relief, which is allowed under ERISA 502A3. Ultimately, a lot of gyrations happen. The court case ends up in front of the 11th Circuit. And the 11th Circuit says, look, we've looked at every other circuit case law, and they've recognized the availability of equitable remedies against a breaching fiduciary. And that remedy is available under the ERISA statute. So the 11th Circuit said, look, under ERISA section 502A3, there is a cause of action for an ERISA beneficiary, the spouse, to recover monetary benefits, the supplemental life insurance, that were lost due to the breach of the fiduciary duty in the enrollment process. So the court granted the motion to amend the complaint. What's happening, of course, is that the court is recognizing that a fiduciary has a responsibility to guide an employee through the enrollment process, to deduct the premiums from the paycheck, and to provide benefits information to them in a correct fashion, submit the enrollment plan, and make sure that the enrollee really does have coverage. I don't think the court was particularly happy that there had been reassurances made to the doctor that he was enrolled and that the employer was deducting premiums for over 3 years. So clearly, under the case law, an employer can be sued for their failure to make sure that the enrollment process is explained and completed properly and implemented properly. That was a great win, and let's hope ultimately that the spouse was able to collect the other $350,000 that was due as a result of the doctor's untimely death. Got it? All right, let's take a break.